Thank you very much indeed, Judge De Gaetano. It's a great pleasure to be back here with ERA again. The issues which I'm looking at this morning are issues which are, or used to be, somewhat tangential to the core issue of asylum that came before the European Court of Human Rights. Classically, for the last 30-odd years, the asylum cases that have come to Strasbourg have been brought by applicants who were alleging that their return to their country of departure, usually their country of origin, would give rise to violations of Article 3 or Article 2 of the European Convention on Human Rights. And it was relatively rare that children and families were involved because in the early days, most of the people who were invoking Article 3 were adults, and they were often single adults, and they were often single male adults. But the geography and geometry of asylum has changed dramatically, and as everyone in this room knows, perhaps the single most pressing and urgent issue that Europe has to deal with at the moment is about child asylum seekers. And perhaps the most worrying statistic of all is the one not put forward by NGOs or governments, but by Europol, that 10,000 children have gone missing within the asylum system in Europe in the last couple of years. 10,000 missing children. Children don't go missing if they have been given the proper protection and the proper support that the Common European Asylum System and the European Convention on Human Rights foresees for them. And every one of those 10,000 children is the consequence of a failure of a system to do what it's supposed to do. So we're going to look at the way in which the European Court of Human Rights has started to look at the situation now of not the typical asylum seeker of 30 years ago, but the typical asylum seeker of the second decade of the 21st century. And before we get into the details, I just want to recall something which we often forget. And that's Article 1 of the European Convention on Human Rights. The high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of this convention. That's a positive obligation on states to ensure that the rights that are guaranteed in the convention not only exist in theory, but are secured in practice. And that's the fundamental issue which underlies what I'm going to talk about. And of course, we've already talked today about the right to an effective remedy, and that is the other half of the partnership that Article 1 and Article 13 form to ensure respect for the rights which are guaranteed. Now, I've been asked to look at the application of Article 8 in the situations with which we are often confronted. And we'll see that Article 8 talks about the right to respect for private and family life, home and correspondence. Unlike Article 3, which is absolute, Article 8 permits of interferences. And there can be interferences, but if they are in accordance with the law and necessary in a democratic society for one of the reasons set out in Article 8.2. There is a 5-point test, which I haven't put in the slides, for deciding whether or not Article 8 has been violated. Firstly, do the facts disclose a protected right? And these are the protected rights. Secondly, has there been an interference with those rights? Thirdly, was that interference in accordance with national law? And was that national law of a quality which rendered it foreseeable and clear? Secondly, did the interference pursue an identified legitimate name, one of the names set out in the second paragraph of Article 8? And which of those aims did it seek to achieve? Because something that is necessary for national security, it may be justifiable, whereas something that is merely for the economic interest of the country may not justify it. So you've got to identify the aim before you can do the proportionality test. And of course, as you all know, the word proportionality appears nowhere in the Convention. It's hiding within the phrase necessary in a democratic society. So we have 4 protected rights in Article 8. Family is one of them. And I want everyone to think for a little bit about who your own family is. Is it your husband or your wife or your partner or your children or your parents or your partner's child from a previous relationship who lives with you, or your ex-step-grandmother's daughter who stays with you every week, or the child that you have already adopted, but you haven't been able to bring to Europe because of difficulties with immigration control, or a child with whom you have a relationship already through a kafala not adoption process in an Islamic country. Are you the father of a child who you are not married to or don't have a durable ongoing relationship with the mother? These are all family relationships which the European Court of Human Rights has had to look at. And in all these cases, the court has said, let's look at the circumstances of the case, and is there a real ongoing relationship between these people? Because it may be that if you're an asylum seeker and you left behind your partner or spouse and children when you fled, you haven't seen them for years. But you always hoped that once you had managed to get yourself established in a country of safe refuge, you would be able to be reunited with them. So there's a huge variety of different situations which we can call family life. There's also the question of private life. I sometimes feel, and I'm sure Vincent will correct me if I'm wrong, that when the court can't think of anywhere else to put something that it feels ought to be protected, it puts it in private life, because otherwise where do you put it? So private life covers a multitude of scenarios. It covers those relationships which are not family life, so close personal relationships. Until recently, relationships between gay couples were thought to be exclusively a matter of private life, but now we have some case law which suggests that if they are in a situation which is analogous to family life, they should be treated as family life, and we should not discriminate against them in our taxonomy just because they are gay relationships rather than heterosexual relationships. Private life, however, has a more interesting element that we'll come to when we come to look at some of the cases, because the court decided a long time ago in a case which was highly criticised because most people thought it should have been a violation of Article 3, which was about a severely disabled child in the Netherlands who was attacked by somebody in the home where she was living, and she couldn't bring a civil case against this person because she lacked the capacity to bring the civil case. It was called X and Y and the Netherlands. And the court found there was no violation of Article 3. It was a long time ago. I don't think the court would reach that decision now. It's got a much more modern approach to sexual violence than it had a long time ago. But what was taken away from Article 3 was a great gift to Article 8, because the court conceived of the notion of moral and physical integrity, that is, psychological and physical well-being, and said that fell within the private life rubric of Article 8. Why is this relevant to what we're talking about here today? Because it may be that an asylum seeker's situation in the country of destination may not be bad enough to reach the threshold of Article 3, but it may nevertheless constitute a serious affront to moral and physical integrity, and in such a case, it will have to be justified by the state under paragraph 2 of Article 8. It's also about the right to develop relationships with people with whom you want to develop relationships or with whom you have developed relationships. And in some cases, the court has found that the right to develop relationships with other people, not just deep personal relationships like a gay couple, but less deep relationships, is also protected by the private life rubric of Article 8. You are also entitled under Article 8 to have your home respected and in many cases people will have lived somewhere for many years, and that's part of why they are alleging they cannot be expelled. Correspondence. When I did these notes, I put correspondence isn't really so important here. But actually, as I've been thinking over the past weeks, and thinking in particular about the children who are held in camps, that for those children, correspondence, which doesn't mean writing letters, it means all kinds of communication with the outside world. These children often have the impossibility to communicate, and they don't have the right to respect for their correspondence if we understand correspondence as the possibility of communicating. And the case that was mentioned earlier this morning about providing the proper facilities so that someone could communicate with the legal aid services is a classic example of this. Article 8 prohibits, not absolutely, but nevertheless prohibits, any interference with the rights protected by it in the country of proposed destination. In Article 3, we have an absolute prohibition and a very high threshold of severity. Under Article 8, the interferences may be justified, but the doctrine of proportionality tells us that the more severe and the more serious the interference, the weightier the reasons for justifying it must be. And you can go away from here afterwards and look at the case of Bouygues against Belgium. Bouygues against Belgium was a very controversial case. It was about a young Maghrebien living in Brussels who was taken into the local police station for identity verification. They needed to identify his identity. His house was next door to the police station, and he'd been in trouble with the police on several occasions beforehand, so one might have thought that they already knew who he was. However, the reason for him being taken into the police station was to check his identity. And in the course of the questioning to check his identity, the policeman slapped him a bit round the face. Didn't do anything that you might call torture, but slapped him round the face. And the European Court of Human Rights found that this was ill treatment which was prohibited by Article 3. Because when you have somebody in custody and you abuse your permission of authority in order to inflict demeaning physical injury on them, the majority of the court found that this reached the threshold of Article 3. There were many criticisms of this decision who felt that it should not have been dealt with as an Article 3 case because it was important for Article 3 threshold to be kept very high, and it might have been better dealt with as an Article 8 case where there was an infringement on personal dignity and private life that was totally unjustifiable and therefore very serious. But that's where the court went, and I think it's important for us to be aware of the fact when we're looking at the threshold of severity in Article 3 and whether it should be Article 3 or Article 8 that are examined in any particular case, we should look carefully at the reasoning in Bouygues and Belgium and see whether or not it's comparable for cases. I think the case of Rahimi and Greece is now so old it doesn't really qualify to be in this session, nor Popoff and France. I'm always getting told off for talking about a recent case, and people say, yes, but it was 10 years ago, Nuala. It's not recent. But both Rahimi and Popoff were very important cases about the infringement of Article 8 rights in the country where the individual was. We already talked about Popoff earlier in this session, and we also talked about Rahimi in relation to detention. We are going to be spending a lot of time referring to cases which are about the inappropriate detention of minors in relation to cases of people seeking asylum or who are subject to immigration measures. The case of Ben Saeed was a case from the UK about a gentleman being returned to Algeria who had very serious mental health problems in the UK. And it was recognised that in the light of the assessments that had been made by the national courts, that it was unlikely to be able to succeed on Article 3, but that nevertheless returning him without the intensive medical treatment that he required to keep him sane, there is no other word for it, was such a serious infringement of Article 8, private life, that he should not have been returned. The court rejected that argument, not because they rejected the point of principle, which is why I'm bringing the case up now, but because on the facts they found that he would be able to access the necessary medication and treatment in Algeria. And then we have the aspect of private life, which is about personal relationships in the country of residence, or the country of presence. And in Al-Nassif and Bulgaria, Mr. Al-Nassif was going to be expelled because he was suspected of activities which were contrary to national security, and his argument was that his family and private life in Bulgaria would be infringed by the interference that his expulsion would entail, and the court recognised that. Slivenko and Latvia is an absolutely classic case, and Slivenko and Latvia is the case about ethnic Russians in Latvia and their long residence and long ties, and the totality of their ties to their place of origin. The place of presence and residence. The reason why these are important, because as we have discussed, some of us, in the past 24 hours, there are people who seek asylum and who, by the time a definitive decision is made, not all of them take as long as BAC against Greece, but by the time a definitive decision is made and they're on the point of actually being returned, they have married, they have children, they have businesses like Mr. Al-Nassif had, they have a settled life in the country. So that it's not just the ill treatment that they would fear that was originally part of their asylum claim, an asylum claim which may finally, after months, years of processing, have been rejected, but they have now put down roots. And the question is whether the roots that they have put down are roots which will justify not expelling them? And the answer is they might. Because all the Article 8 cases are fact-specific. And it's about the extent of the relationship that the individual has with the country of residence. And then we have people, oh, I'm going the wrong way, yeah. We have home, we have your home is a de facto and a de jure concept. The Gillo case concerned a family who lived in the Channel Islands, or perhaps as we're in France, we should call them les îles Normandes, which are closer to France than they are to England, but by a quirk of history belong to the United Kingdom. And they left their home and went to work in an international organisation, and when they wanted to come back, they weren't allowed to come back for immigration reasons, because the Îles Normandes have their own immigration system, which is separate from the UK's. And they couldn't get back. And the question was this still their home, even though they'd been away from it for 17 years? And the court said, yes, it was still their home. Blecic and Croatia was a comparable case because it was about an old lady who had fled Zadar during the troubles in, I use the word troubles because I have connections with Northern Ireland, and we use the word troubles to describe any kind of civil unrest, upheaval, bombing, killing, shooting, sniping, whatever. Mrs. Blecic had left Zadar during the troubles in Croatia and had fled to Italy, where she had gone to stay with her daughter. And when she came back, she wasn't able to get back into her house because her house had been appropriated with state sanctions by a Croat of Croatian ethnicity. The case caused enormous discussions because it was held that the decision as to when she lost her home took place before Croatia had ratified the convention, even though the Constitutional Court's decision endorsing the decision that she had lost her home took place after ratification. I cite this case now because although happily the troubles in the former Yugoslavia are mostly behind us, there are still people who need to be able to return to homes which they left in many Council of Europe countries, because in many Council of Europe countries people have fled from their homes and sought temporary refuge somewhere else and then want to get back to them. And that's a problem in a lot of places in the more eastern parts of the Council of Europe's domains. You can see where I've said correspondence is less relevant, but that was before I rethought this about particularly children in camps being able to communicate. And because there is actually a very important case called DL against Bulgaria, which is about a child being placed in a centre for special education. It's called Children in Crisis. Basically, it's for children that you're not putting in prison, but that they're too badly behaved to be allowed to be kept at home, in a way. And in DL and Bulgaria, one of the things that led the court to find violations was the fact that DL, the child in the case, had very limited opportunities to communicate with the outside world. And many of the young asylum seekers and in particular the children, have been given by their families mobile phones, and they do get in the camps some possibility to charge those mobile phones, but not enough for them to be able to keep regular contact with their families, their lawyers, and the NGOs who are ready and willing to help them. And we see this particularly on Lesbos, on Chios. We saw it in Idomeni. We've seen it all over Greece. I'm not sure what the situation is. Maybe somebody in the room can tell me if this is a problem in Italy, in the SPRAs, is it? Anyone? Judge De Gaetano has very helpfully given me the site for DL in Bulgaria. It's the 19th of May 2016, so it does count as written. I'm afraid that about 3/4 of the cases to which I'm referring only exist in French. But sometimes, if they are directly about asylum, if you don't read French, you can find them on the EDAL website. And sometimes you can find on the HUDOC site legal summaries of the case, and sometimes you can find press releases. But if anybody has a query about a particular case that I mention, and they don't read French, and if Babelfish, or whatever it's called, won't do the translation, you're very welcome to contact us at the Air Centre. I want to move on now to a very important provision of the Convention in relation to my presentations, and that is Article 53 of the European Convention on Human Rights. And it's very clear. Nothing in this convention shall be construed as limiting or derogating from any of the human rights and fundamental freedoms which may be ensured under the laws of any high contracting party or under any other agreement to which it is a party. Let's look first of all the laws of a high contracting party. Obviously, that means national legislation, national laws. So you can't interpret Article 8 in a way which is more restrictive than the interpretation to a particular phenomenon that is given in national law. But with regard to EU law, we have a particular issue, because if the EU law in question is a regulation, then it's directly applicable in all 28 member states of the EU, and it may also apply in those countries of EFTA to which it has been extended. If a directive has passed its transposition date, then it is also directly effective if it hasn't been transposed or properly transposed. And that's under the laws of any high contracting party. So we can't have, we talked about detention yesterday, we can't have a regime under the European Convention on Human Rights, Article 5, which offers less human rights protection than is given under the Reception Conditions Directive or the Asylum Procedures Directive, or indeed the Returns Directive, where that's applicable. We discussed all of that yesterday. The reason why I've introduced Article 53 here is because of the other agreements to which all member states of the EU are parties. And we'll be looking at several of those agreements as the morning goes on. Morning's nearly finished. The UN Convention on the Rights of the Child has been ratified by everybody except the US. And Somalia hadn't ratified it, but there's now some question that Somalia may, in some form or other, to the extent that Somalia has a government, has ratified it. So the US remains. Until last year, it was ratified by the UK, but not applicable to les îles Normandes, because they hadn't had it, but they have now. So it's a global instrument, the Convention on the Rights of the Child, and I hope that the text of Article 3 is in a font which is readable. In all actions concerning children, just read that first few words again. In all actions concerning children. And we could insert into that all actions and omissions concerning children, whether undertaken by private or public or private social welfare institutions, courts of law, administrative authorities or legislative bodies, the best interests of the child shall be a primary consideration. And because Article 3 of the Convention on the Rights of the Child forms part of the legal framework of the European Convention on Human Rights by virtue of Article 53, it is essential that when we are looking at any act or omission concerning children, that there is evidence that shows that the best interests of the child have been and continue to be a primary consideration. And this means that national authorities will want to ensure that in their decision-making processes, they can demonstrate that the primary consideration has been given to the best interests of the child. The best interests of the child is not, under the CRC, a paramount consideration, but in the national laws of many countries, the best interests of the child is paramount, though not normally in immigration and asylum. But the fact that it's not paramount does not diminish the fact that it must be a primary consideration, and it must be seen to be a primary consideration. And the European Court of Human Rights is getting better at referring to Article 3 of the CRC in cases. I did suggest to one of the judges recently that in any case concerning a child where the child was of an age where under Article 12 of the CRC his or her views should be taken into consideration, the court should ask in its questions to the parties, and in the governments in particular, whether the views of the child had been taken into consideration in these proceedings. And individual judges and sections are quite good about doing this, but it's not universal even within the court. But it's very important that in all cases concerning children, Article 3 of the Convention on the Rights of the Child is taken into account, and that their views have been heard if they are of an age where they're capable of giving voice to them. Very important. I'm not quite sure how adaptable age got into the top of this slide. Do you know how computers do things when you didn't really ask them to do it? Well, adaptable age is a doctrine of the Court of Human Rights, and which has either come from the member states or has gone back to the member states from Strasbourg, which says that it's okay to insist that a child uproots from the home they've known all their life and go and live somewhere else on the other side of the world for some reason to do, not with them, but with their parents, if they are of an adaptable age. And we'll look at that in a minute. Jeunesse and the Netherlands concerned a family in the Netherlands. The father was Dutch, the children were Dutch, the mother had been Dutch, but when Suriname got its independence, by operation of law, she ceased to be Dutch. And she was having a little problem regularizing her status in the Netherlands in order to be able to stay with her Dutch husband and her Dutch children. And, of course, as a matter of EU law, as the parent of a Dutch child, she had the right to stay in the Netherlands if the Dutch child would otherwise have had to move out of the territory of the European Union. Because in the case of Ruiz Zambrano, the court held that a parent, a third country national parent, had to be given the right to reside if this would mean that the union citizen, and these Dutch children were union citizens, and the Dutch husband was a union citizen, would have to leave the territory of the union. So to those of us who knew EU law, it seemed to us a foregone conclusion that she had to be able to stay, because otherwise the children would have had to go to Suriname. And the Dutch authorities were of the view that Suriname used to be Dutch, and everyone spoke Dutch there, so it wouldn't hurt these children to these Dutch children to pack up and go to a former colony on the other side of the world. We suggested in Jeunesse that the comparator should be another neighbouring European country, because these children had the right, and this family had the right, to live anywhere in the European Union, so we shouldn't be talking about whether it was a good idea for them to go to Suriname or not. But in the end, the case was sorted. The European Court of Human Rights, Grand Chamber, found it would be a violation to oblige them to go to Suriname, where they wouldn't have gone anyway. And they have now, my understanding is, from the execution of judgments, Mrs. Jeunesse has now been given a residence permit. The case of Bao in Denmark was a very similar case. The Bao family were of Ghanaian ethnic origin. Mr. Bao was a Danish citizen, and their children were Danes, so it was the same story as Jeunesse. But Mrs. Bao, they wouldn't regularize her position in Denmark because they didn't meet the criteria for family reunification. The Danes had a rule which applied different and more relaxed criteria to people. Is there anyone from Denmark here? No? Yes. Correct me if I'm wrong on Bao.
I will as well. I was in that case.
Oh, you were in that case. Okay, good. Oh dear. Anyway, so they wouldn't allow Mrs. Bao to be regularized in Denmark because they had a rule which said in order to be regularized as the spouse of a Danish citizen, there were two sets of rules. One set of really easy rules, which are for people who have been Danish citizens for more than 28 years. And another much harder set of rules for people who have not been Danish citizens for more than 28 years. Mr. Bao was a Danish citizen. Can you all for a second close your eyes and have a visual picture of Mr. Bao, a Ghanaian citizen naturalised as Danish? Now can you close your eyes and think of what a Danish citizen who's been Danish for more than 28 years looks like? Do you have a visual difference? We say no more. In the end, of course, because they were all citizens of the European Union, Mr. and Mrs. Bao and the children, when Mrs. Bao was not allowed to live in Denmark, did what any sensible Scandinavian does. They moved across the bridge to Malmö. Has anybody seen the detective story of the bridge on television? That bridge. They moved across the bridge to Malmö. The children then had to go to Swedish schools, which, you know, some people would say was not too much of a disadvantage. And Mr. Bao continued in his job in Copenhagen, and he got up every morning, and instead of getting the bus across Copenhagen, he got the train across the bridge from Malmö. And as was recognised at any time, and this was recognised by the Danish government, at any time the Bao family could have applied to come back from Malmö to Denmark under a principle of EU law called Surinder Singh, but they still maintained that they weren't going to regularise her in Denmark and that she'd have to go to Malmö, live there for a bit, and come back in order to get her regularisation. The court found a violation of Article 8 for a whole lot of rather convoluted reasons. Does that summarise? With Article 14. Is that a correct summary? More or less. I always love the idea of them getting up and going across the bridge in the morning. The CJEU has recently revisited the judgment in the Ruiz Zambrano case, in a case called Chavez Vilches. There's an awful lot of in this, aren't there? Can we just call them with a Z? Where we're looking at whether or not what we call Zambrano parents, that is the parents of EU citizen children, have the right to reside and the right to have benefits. The Returns Directive should theoretically apply to anybody who has had their claim for asylum or their immigration status claim refused and by a final decision. And the Returns Directive was much criticised when it was introduced, but the Returns Directive is a disputed instrument, but it does contain some very valuable safeguards for people who are being removed. In particular, some restrictions on the length of detention that is permitted, which is an issue that the Court of Justice in Luxembourg has looked at, as indeed the court here in Strasbourg had some looking at it in the case of Katsuev against Bulgaria. I ought to know, it was my case. Anyway, but the important point from asylum is that the Returns Directive may not necessarily apply to people who, as you see, are in border procedures. However, the importance for our theme this morning is that the Returns Directive, let's go back to Article 53 ECHR. So this is not just about EU law as an interesting and useful thing. It's part of the ECHR. Is Article 5 of the Returns Directive, which requires states to take due account of the best interests of the child. And what does due account mean? It means it must be a primary consideration, because that's what it says here. So Article 5 of the Returns Directive means that member states shall have the best interests of the child as a primary consideration when they are implementing the Returns Directive, as well, of course, as the principle of non-refoulement. Then we move on to Hoonah and the Netherlands. It is unfortunate that there are so many people who are seeking international protection or who are in a vulnerable or precarious immigration status who also manage to have collected criminal convictions. This does not help them. But the case of Hoonah and the Netherlands sets out very clearly a whole series of reasons that have to be taken into account in deciding whether or not the expulsion of somebody who has got close family ties is justifiable. And amongst the criteria that have to be taken into account is the strength of the family ties which exist, the seriousness of the convictions, how long ago it was that the individual was convicted, and has he shown a propensity to reoffend? And all those matters have to be taken into account. We had a case which isn't in my slides, but I'll tell you about it, which was, well, two cases actually. A case called AA against the UK, which was about a young man who had come from West Africa somewhere to join his mother, who was working in the UK. Perfectly legitimate immigration status. And he lived in a rough part of South London and got in with a group of boys who were very badly behaved, and they all went off to a girl who was in their class at school and sexually attacked her, a group of them. It was not pretty. And he was a child at the time, 15, 16. He was prosecuted and convicted, and because of the seriousness of the attack, and I absolutely, totally agree that it was a very serious attack on this poor girl. And he was sent to a youth offenders institution. He had a very, very strict religious West African mother. And I suspect that she was more trouble to him than the police or the judges. Anyway, when he was in the youth offenders institution, he managed to get so many qualifications that the school thought he ought to be a 5-star pupil. And then he went on to university and got a very good degree. And then he had just been accepted to go and do a master's when a letter arrived on his door saying, we are revoking your permanent residence in the UK because of the seriousness of the offence which you committed 10 years ago when you were a child. It might not be 10. And the case went through the British courts, and we took it to Strasbourg, and I'm happy to say we were able to win, and he was able to go ahead, complete his master's, and he now has a very successful career and has never, ever, ever offended since. We had another case called Mr. Omojudi, who is named, so we don't have to not name him. And that's rather sadder because he was also convicted of a not so serious offence and was deported to West Africa, leaving his wife and children at school and university in England. And we won his case in Strasbourg. He had a quite serious medical condition. The medical condition was not part of the thing, it was the family life. We won his case in Strasbourg, And unfortunately, he died of a heart attack before he could be brought back to join his family. A sad story. National security. We talked about al-Nassif already, but I just wanted to mention CGM Bulgaria because sometimes government departments have a tendency not to be terribly careful when they are justifying, when they are justifying their actions. Mr. al-Nassif was genuinely, though not explicitly, but genuinely suspected of activities which threatened Bulgarian national security. Mr. CG was also expelled under the provisions for people who were threatening national security, not under the provisions for criminals, and he was a drug dealer. He wasn't a drug dealer with any links to terrorism or any other classic national security. He was just a perfectly ordinary criminal drug dealer, and the court said it was really not appropriate for them to invoke national security in relation to drug dealers who were just criminals. Caused some stir, but it worked like that. Hoonah and Abdi is a very important case because the UK had rules which related to family reunion for refugees. And the rules for the spouses of refugees who were in relationships which were formed before flight were more favourable than the rules relating to the spouses of refugees who formed those marital relationships after flight. And the court looked at this and said it could find no justification for this discrimination between pre- and post-flight marital relationships, particularly when people with temporary status, because until refugees get permanent residence, they have temporary status. Other people with temporary status, like students and workers, were allowed to bring their post-arrival spouses in. The government had an interesting argument to run in Hoonah and Abdi, and they said, well, we want to encourage students and workers to come to the UK, but we don't want to encourage refugees to come. So we're entitled to give incentives to students and workers to come, but we're not entitled, but we don't have to give the same incentive to refugees. And the European Court of Human Rights did not like this argument. And you can almost feel the irritation of the court through the beautifully, elegantly worded sentences in which they explain this. I think we've already spent quite a lot of time this morning on the right to an effective remedy, so we're not going to go into that again. And, of course, there is our good friend BAC. It's wonderful. It's like the record for an Article 6 length of proceedings case is one against Croatia when the civil proceedings took 22 years. But, of course, we can see that the length of proceedings will violate private life because of the uncertainty in which it places you.